Well, good morning, everyone. Appreciate you taking the opportunity to listen to me talk for a little bit. This is going to be an overview. They asked me to speak about 15 minutes on state compliance. I'm going to focus in on licensure, prescribing, privacy, and reimbursement. We have a 15-minute section at the end where you can ask questions, but please feel free to raise your hand, ask me a question as we go through the presentation. Very informal. So let's get started. So state licensure, we're dealing in the context where every state's in U.S., every state licensed professionals, whether they're physicians all the way down to the nurse practitioners, nurses assistants, and the like, psychologists, psychiatrists. And in this context, it's been formed that the location where the patient is located, that individual practitioner needs to be licensed in that state, as well as in the state in which the practitioner is located. So if we're dealing with an operation that's within all 50 states, there's going to need to be the individual that is having the consult with the patient be licensed within that state as well as the state in which you're operating. There's some concept where obviously that doesn't necessarily make sense to the telehealth operations and the way that it's structured, but that's the way that we need to make sure that there's compliance in the states in which they're practicing. So licensure exceptions. States have recognized that there are instances, well before telehealth and the like blew up, there are instances where those individual physicians or practitioners do not need to be licensed by that state. So those are the exceptions that I'm referring to. There is reciprocity with adjacent states. They're recognizing those physicians can be licensed within their states without having to go through that process. There's special telehealth licensure certification processes that makes it easier for them to be licensed within the state. And then there's consultation services, follow-up visits, and limited encounters. Alabama has one of the most interesting laws on the limited encounters. They're very explicit about how many times you can engage with a patient in that state before you actually need a license to practice in that state and perform the services. Of course, there's movement in the direction to have compacts within the states to recognize each other's licenses. Reciprocity is the key. We have the compact with the Federation of State Medical Boards. There's for physicians for the nurse licensure compact, obviously nurses, and then there's the interjurisdictional compact and Psych Act that are moving and transgressing. They require state legislatures to pass and adopt those compacts, recognize that they're appropriate, and if they don't, then they're still subject to the formal process within the state boards. This is just an example of a difference within the states. The fact is that you have to look at each state. Not every state has the same processes. Not every state recognizes similar exceptions. And so, as an example, none of these states have actually adopted into the compact that we're referring to. And some of them have reciprocity, some of them have consultations, exceptions, and some of them don't. So again, we need to be focused when we're working with our clients to make sure that they understand what the framework is within each state. Within the state licensure, this concept of the corporate practice of medicine is very relevant. That concept generally is, as it says here, it prohibits a business corporation from practicing medicine or employing a physician to engage and provide medical services. Really what's underlining that concept is that you don't want the physician or any licensed professional to have their independent medical judgment impacted, directed, controlled, or influenced in any regard. And so some of these laws, as they play out, they're based on case law, or there's actually statutes within the state that define that construct and prohibit it. But of course, in law, there's always an exception. So under these exceptions is the professional legal entities, permission of a professional association, a professional corporation, a PLLC to exist, to be owned and operated by licensed practitioners. So for liability purposes, obviously, they want the practitioners, physicians and practitioners to have the business liability protection similar to any other corporations. But the restriction being that the owners of that corporate entity are licensed practitioners. Now, some of the states also go further and say not only do the owners have to be licensed, but the directors and officers also have to be licensed. And so you need to be aware of that states differ on that approach and what their requirement is. Then the last is the concept. So say you have a New York entity that wants to operate in California and provide medical services. The truth is there are a handful of states, 5 states, California being one of them, that would require an actual domestic entity to be formed in order to provide services. So a New York professional corporation could not provide medical services as a foreign entity in California. You have to form a domestic entity in California in order to provide services through that legal entity. So there's not many states that require that, but it's something to be aware of in the process when you enter into different markets. So this is just, again, California, New York, and Texas, the construct of what is corporate practice of medicine. Again, as I said, some of them are formed by case law, some are formed by statute, and also there are regulatory agency opinions and attorney general opinions that expand upon that over time. So remote prescribing, these are the 4 questions that you necessarily need to ask when you're going to engage in prescribing non-controlled and controlled substances to patients in specific states in which they're located. My colleague is going to be speaking tomorrow more in depth on prescribing and the parameters around that, specifically associated with the opioid crisis that we're dealing with. But who can prescribe via telehealth? What can be prescribed? What is the criteria for establishing a physician-patient relationship or a relationship necessary to do so? And is a physical examination required? These are issues that differ on a state-by-state basis, and therefore you need to respect and understand what those are, and they're changing on a regular basis. So we know that every state does have some form of laws on the books that would affect remote prescribing, but of course that concept has not necessarily been picked up by all the states. There are a handful of states that are in the process and have actually passed controlled substance laws specifically related to telemedicine. I've cited a few here, Michigan and Ohio. Ohio mirrors the Ryan-Haight Act and exceptions for controlled substances, which I'll reference in my next slide. But then as you'll see in Tennessee and Virginia, while it's not on the books, statute or regulation, the medical board has gone and to provide their opinion on what they believe is necessary in order for a licensed physician to be able to prescribe controlled substances via telehealth. I think the underlying concept and thing that's important to understand is it's a movement in the direction that medications can be prescribed via telehealth. It's a movement in the direction that controlled substances can, but we need to be respectful of federal law. The Ryan-Haight Act that many are familiar with does otherwise limit the ability to prescribe controlled substances via telehealth without a first initial in-person physical examination. There are exemptions to that rule, which I list here. I think one of the primary ones that is important is the special registration. That's the ability to register with the DEA to be able to prescribe controlled substances if you are, in fact, licensed and meet all of their criteria. The problem is the DEA has never passed that, developed that criteria, and never opened up for special registration, and it's going on 10 years now. But married with that is the concept that we're not really seeing enforcement on this issue either on the federal level by the DEA. And few and far between is when we do see it, when we see that there is some public stir about it, that they'll make an issue. But right now we're of the position the DEA hasn't taken much attention to it. So patient privacy and confidentiality laws. General, of course, we have HIPAA that we need to be compliant with, both the privacy rules, security rules, and breach notifications associated with that. State laws on their privacy and cybersecurity rules is something that's come to fruition more. We're seeing more and more of states passing cybersecurity laws, not just solely related to healthcare services, but related to, especially when hospitals or large institutions are getting dinged and otherwise being hacked, then there are laws, states that are starting to pass those laws that we need to be and follow and be aware of. They would define how our operations would allow us to access that information, store that information, share that information, all of those pieces that we need to be aware of. The Federal Trade Commission Act, and again, you need to be aware of how you're sharing that information and the constructs behind that. So reimbursement. Again, this is an overview, so this is a slide that otherwise it indicates. I mean, we have most of the states now, 50 states, that are covering some form of telehealth, telemedicine services for Medicaid programs. The point is, in this slide, and we'll discuss a little bit more, is the differing coverage and reimbursement policies. Not every state, again, is the same, and so we need to make sure that when we're advising clients that we go through and we recognize what those parameters are. 37 states in the DC have commercial health plan parity laws. Again, the definition of commercial health plans differs state by state. ERISA health plans are exempt from those parity laws because they're subject, obviously, then those health programs are subject to the federal laws. Only 4 states have true parity laws, which says that not only the coverage has to be the same, if you can provide that service in person, you can also provide it via telehealth, then that has to be covered, but there's an absence within those state laws that actually say, and you need to reimburse it at the same amount that you would an in-person visitation. So those are issues that are significant, and they're playing out, and payer issues, as we see them, are going to grow when the state legislatures fail to include that type of language. And one distinction I'll point out in New York, for example, Medicaid and commercial health plans. So there's a provision within New York laws where Medicaid covers only certain services, only provided by certain physicians, and then there's a whole list of the appropriate practitioners. But when you get to the parity law for commercial health plans, it doesn't have that same limitation. It's a very broad provision. So there's, even within the states themselves, there's differences in what is the coverage requirements both between Medicaid and commercial health plans. So this is a table or a chart that's courtesy of CTEL in the last fall summit, where we're mapping out the states that have parity laws, those that have them proposed, and those that do not have parity laws on the book right now. That's mainly for reference, but you'll see that that's a movement in that direction, that the legislatures are taking a note of that. So Medicaid coverage, the limits on coverage services, such as Medicare has their geographic limitations, their provider limitations, and the type of services. When you go to each state, they may also have those limitations. So the modality is how that service is provided, asynchronous, synchronous, store and forward. There are limitations on what is going to be covered by the Medicaid programs. You got to look specifically to the regulations and the guidance on that. Geographic area, some of the states do still have limitations on geographic area. Definition of healthcare provider and permitted patient site and or originating sites. These are all things that differ on a state-by-state basis and need to be vetted out when you enter into a state market. So this is just a list of 48 states that do reimburse for live video for Medicaid. 28 states limit the type of facility. 21 states reimburse for remote patient monitoring. 15 states reimburse for store and forward, and there's 6 states that have that geographic restriction. So now our firm has been involved. Feedback. Our firm has worked with BNA Bloomberg to produce a periodical. The periodical goes through its 13 chapters all the way to international health, telehealth issues. This is last year, and so there's a revised version coming up. We have a contract with them to update it on an annual basis. But this is a great reference source. We even use it ourselves when we're advising through. But it goes through even more just the reimbursement, prescribing, privacy, and rules. But there are additional issues that are helpful. Our firm represents not only telehealth providers and health IT companies, but we also work with private equity firms, having them understand the landscape associated with these services. A lot of that has to go around the corporate practice of medicine, what they can invest in, how that's structured properly to be compliant with those state laws. And we have a number of resources in addition to this periodical, which is a private periodical through BNA Bloomberg that we've contracted with them. But the firm has a number of resources that can be utilized and referenced to understand the landscape and have some specific questions answered. So at that, I'll end and open it up to any questions.